Andrei Iancu served as the U.S. Undersecretary of Commerce at the USPTO, director for 3 years, where he was most arguably the most effective and pro-patent director in the office's history. Many of you know that. He continues his leadership as chairman of the Council for Innovation Promotion and as a partner at Sullivan and Cromwell. Director Iancu believes, and I don't think I'm speaking unwisely for him, it is no accident that America's rich history of innovation, IP rights, and democracy are inextricably linked. Andrei?
Thanks, and especially for using a picture that's 25 years old at least. I appreciate that. You need to morph that into my real self somehow. Maybe Dolby can invent some technology to that effect. Great to be here with everybody. Good to see a lot of familiar faces, and kick off what's I'm sure is going to be a fantastic day of conversations about the state of IP. And thank you to Dolby and Andy and everybody else for hosting us, and Bruce in particular for putting on a conference like this every year. I've spoken at this event several times in the past, including when I was at the PTO. To be frank, the themes that we keep talking about have not changed all that much, but the context has, and the talking points surrounding similar themes about the importance of IP and how to balance the rights of owners versus the rights of users and so on. The framework has changed both domestically and internationally. And unfortunately, a lot of it is driven, I believe, by a lack of understanding, obviously, about IP anywhere else outside of this room. I was reminded just this week. You know what the anniversary is this week? Anybody? What is the United States celebrated this week? Anybody know?
Years of YouTube.
Oh, fantastic. Okay, see, this man follows me everywhere. He was in Kentucky yesterday, also knew the answer yesterday. It is true.
I like the right for jury trial.
It's 250 years of Paul Revere's ride. And I don't know if kids know about that anymore nowadays, but obviously Peter still does. And so I had occasion as a result of that to go back to Longfellow's poem about Paul Revere's ride, which I'm sure took place exactly as he said. And the poem begins with, as many of you will recall, "Listen, my children, and you shall hear of the midnight ride of Paul Revere on the 18th of April, okay, in 75. Hardly a man is now alive who remembers that famous day and year, except for Peter Harder." And goes on describing in great detail what happened on that ride. He was going around saying, allegedly, the British are coming to kick off the American Revolution. And then it goes in detail, says, "It was 12 by the village clock when he crossed the bridge in Medford town," on and on. "It was 1 by the village clock when he galloped into Lexington. It was 2 by the village clock when he came to the bridge in Concord town," and so on. So when was the last time you had to gallop to transmit a message that took an hour in between neighboring towns? Obviously, everything we do nowadays, we sort of take for granted. You're sending instant messages, and you don't have to send Paul Revere to announce anything. You're just going to take your phone out, many of you are on it right now, and texting instantaneously to everywhere in the world. We just take this for granted. And only 250 years ago, the state of communications was the same as in antiquity. Put that in context. Human civilizations have been around for millennia. We've heard about, I've been speaking about this in the past. thousands and thousands of years of civilizations, the Greeks, the Romans, the ancient Chinese, the Mayans, whatever, and yet 250 years ago, it was the same as in antiquity. It took weeks to get news of the Declaration of Independence, just a year or so after the Paul Revere ride. Weeks to get news from Philadelphia to the rest of the country, to Richmond, Virginia, the capital back then of, and other places. Just as long as it took Alexander the Great to get news back to Macedonia of his victory of the Battle of Arbela in 330 BC. Same, 250 years ago. And you know, if you wanted to have a meeting like this, we would do it by candlelight. Only 250 years ago. And I say this to highlight the fundamental point that is lost to most. We are just so steeped in innovation. We are just so used to innovation right now. It just happens miraculously. Here we go. We just turn around. Yet another day, another amazing new feat by ChatGPT or something. It took over 100 years for the US Patent Office to issue 1 million patents. Nowadays, we're issuing 1 million patents every 3 years. We are so steeped in it, we've become completely blasé to the human endeavor. And as a result, we just believe that innovation happens. But innovation doesn't just happen. Because if it did happen, all the things we're doing now would have happened over the thousands and thousands or even hundreds of thousands of years of human existence on this planet. Innovation does not exist in a vacuum. Everything we are accustomed to nowadays, all the innovation that we expect, and the pace of innovation has taken place with no exception under the modern system of intellectual property, which democratized invention when this country was established. For the first time in history, in human history, innovation was democratized. It was not only for the rich. It was not only for those who were friends with the crown. It was not only for those who had a lot of money to build big factories and manufacture products at scale. It was for everybody. It was for the inventor in the garage, for Thomas Edison in his laboratory, and for Ray Dolby here in California. Everything we have today is based in that system. So anyone who says that we should delete IP, obviously, no rational business person would ever say such a thing. But who knows? Some might. Whoever says that, they better have an alternative plan that is proven with some statistical analysis that it would work better than what we have had in place for 250 years. So the result of this misconception that innovation just happens, and then the IP system perhaps is for the clever ones who just after the innovation happens want to use it to pull the ladder up behind them. For those people, as a result of that misconception, a lot of policies are being bandied about in order to weaken innovation. And folks need to ask, what are the motivations behind this? For some, it's simple misunderstanding, they don't know. But that's not an acceptable answer for the policymakers in Washington, whether it's in the administration or on Capitol Hill. It's not an acceptable answer that you have a misunderstanding for people running our largest businesses. So what is behind all of this? Well, there are large established corporations that want access to technology at depressed rates. There are foreign countries that would benefit from the depression of American intellectual property values. And I do think that there are a few who have ideological points of view that, for whatever reason, ideas belong to everybody and should not be monetized in any way. But for one reason or another, whether it's misconception, whether it's economic interest, or whether there's geopolitical forces at play, we are in a situation for the past couple of decades that the IP system, and in particular the patent system, but increasingly so nowadays the copyright system as well, is under severe attack here in the United States and in some ways around the world. It is in some way death by 1,000 cuts. So let me talk about a few of those issues, and then we can open it up to questions and have a few minutes of a conversation. So first of all, in the United States, we have reached a point where it is extremely expensive to enforce intellectual property rights, and in particular patent rights. And unfortunately, this was done by design. And it's a perverse result, because what we've been told all along is that we're doing these various additional policies in order to reduce the cost of enforcement and litigation. And yet, we are at a situation where it's more expensive and more difficult to enforce IP rights than ever before in history. There are multiple proceedings. You cannot enforce a patent in a single proceeding in the United States. There are multiple proceedings every single time you try to enforce a patent, at least in district court, plus proceedings at the patent office, and sometimes at the ITC, and sometimes, let's not forget, that the ITC is in the administration, and the patent office is in the administration, and sometimes there are proceedings at the same time, in parallel, between the same parties, on the same patent, with the same prior art references, in the same administration. And sometimes they reach opposite results. How is this efficient? And how is this good policy? These multiple proceedings have been introduced, as I said, by design, and they're having the opposite effect that they were meant to have. In addition to this, there is, in the United States, for patents, never a time when they achieve quiet title. Again, by design. Virtually no other major jurisdiction has this. And how can you have a valuable, meaningfully enforceable property right when the property owner never achieves quiet title? When the entity that issued title never reaches finality? If you have a city that grants deeds to land, who will ever buy land in that city to build factories and buildings on the land deeded by the city if the city forever into perpetuity reserves the right to revoke that deed? What property system ever in history, in the modern world, not just in the United States, but yes, in the United States and the rest of the world, has such a system? Yet this is the system we have in the United States by design. And it depresses the value of that intellectual property. So first, we have this very expensive system to enforce. Second, even beyond the expense, there actually is no effective enforcement to your property right. Again, by design. by incredible pressure over a long period of time on the courts, they have removed the most fundamental attribute of a property right, which is the right to exclude, removed in the United States, which is the one country in the world that has intellectual property rights in its foundational document, in the Constitution, and it's not just intellectual property that they put in the Constitution. They precisely, the one thing they put in the Constitution about it was the right to exclude. It's no other attribute that they put in the Constitution about patents and copyright. The one attribute they put in is the exclusive right to authors and inventors for their respective writings and discoveries. And yet this is the precise right that the Supreme Court, which is meant to enforce the Constitution, removed from the patent rights. So how can you enforce an exclusive right without the right to exclude? Yet this is the status quo in the United States. So in addition to being expensive to enforce, you actually have no effective enforcement mechanism. On top of this, third problem we have is that the laws are extraordinarily confusing. When I was at the patent office, I used to say, sorry, PTO, trademark people, there's also a T there. When I was at the patent and trademark office, I used to say that there is a hidden law of patent law. It's hidden in 35 USC section 101.5, which is patent laws shall not be simple. And if they are, the courts will step in and make sure that they're not simple. We've had, since 1793, the same statute that says what is eligible for patent in the United States, 35 USC section 101. It's the same today as Jefferson and Madison wrote it for the Patent Act of 1793. Pretty clear what's patentable: process, manufacture, composition of matter, and so on. So they had to confuse it, and we have an incredibly confusing state of section 101 that remains the case. And it's not the only area. There are many other areas. It's just the first one and most glaringly confusing. Virtually no other, no other major jurisdiction, patent jurisdiction, has the eligibility problem that we have. And we invented, basically, this, the modern system of patent law. Yet we are the ones that have trouble knowing what's in and what's out of the patent system. And finally, we have overregulation or attempts to overregulate, and we see that over and over again with the attempts to overregulate artificial intelligence and the disclosure requirements for artificial intelligence innovations, to overregulate standard essential patents as if their standard essential patents are of a different breed somehow, and the market, the free market system cannot function, and it needs the government. And obviously, the government knows better than the market players in this complex area of law, so they need to regulate that as well. The overregulation of IP in the drug space. Over and over again, there are attempts to overregulate here in the United States, and obviously globally. But these issues are not just domestic. They're happening overseas. In Europe, IP sits at the intersection of their regulatory ambitions. They want to regulate there even more than we do here in the United States, although I think we're giving them a run for their money, and their desire for industrial policies and competitiveness. So once again, we saw the proposals there for a standard essential patent regulatory court, which, by the way, this tells you everything you need to know. They wanted to put the standard essential patent board at the European Trademark Office. Thankfully, they gave up on that, at least temporarily. In China, we see that they are taking advantage of some of these weaknesses, but there is a vast and state-driven intellectual property system that's trying to overregulate and aimed at global rate setting and standard setting, and they're using it for their massive industrial policy system. These efforts are worldwide, but nowhere, in my view, as pronounced as here in the United States. And now, the challenges that we face go even beyond that. They're not only legal. The challenges that we face are also strategic. And we see this discussion as it's developing, as it's played in front of the national audience right now. They're also strategic. For example, let me ask this. Will intellectual property remain a framework, at least conceptually, for openness, collaboration, and global standards? Or will it fragment into a patchwork of regional rules and protections, undermining interoperability and trust in the technology ecosystem? We have worked for decades to create a multilateral system of IP, such as the TRIPS agreement, and then, of course, PCT, Madrid, and others managed by WIPO. Will these be maintained, or do we go back to fragmented systems? This is a fundamental question that's very relevant to the conversations that we're having today, and in particular with respect to the trade disputes. The consequences of fragmentation would be acute in the intellectual property system, and they would be most acutely felt by the creators, by the innovators, by the startups, by the small and medium businesses. Because the large established corporations that are global in nature can take care of themselves and maintain their market dominance because they're already there. But that would stagnate and limit the ability of the new companies coming around, the new ideas coming around. They would become fragmented and isolated and have difficulty reaching an international market. Without coherent, trusted international IP systems, the global startup system cannot scale. The university spin-out cannot license across borders. And scientists at research companies, universities in countries around the world will not be able to protect their inventions on equal terms. A robust, predictable IP system that is enforceable in jurisdictions across the world in predictable and expected ways that are normative to expectations lifts all boats. When it comes to intellectual property, fragmentation and isolation harms the United States and our startup economy and our innovation economy. Let me make it even more clear. Of all the areas of industry, the United States has one area where it has a clear-cut trade surplus, and that is intellectual property. And it's not close. And our trade surplus on IP with China is especially pronounced. Those who want to weaken intellectual property, they're doing it by design to weaken the value of American intellectual property and American innovation. And because we have a trade surplus in this area, weakening that American asset will reduce that trade surplus and reduce the value of our most important asset in today's economy. And anyone who argues for weakening intellectual property rights is doing it precisely to weaken the value of American innovation. And as I said at the beginning, there are various reasons for this, but none of them are helpful for the United States. So for an innovation economy to continue the way we are used to, democratized and equipped to actually provide the tools of economic growth, we need to continue to have strong, predictable rights, but also, importantly, rights that that create collaborative environments across the world. For intellectual property, multilateralism is critically important to be maintained. And the examples of this are many. Take, for example, simply just in the past few years, the COVID vaccines. Because of robust intellectual property systems across the world, there was more collaboration in creating the innovative vaccines in record time across borders and distributing it to the market at unprecedented speeds. Could it have been even faster? Sure. But the speed was unprecedented. To create vaccines in less than a year for a new disease, it's never happened before in history, not even close. And you saw collaborations between small companies and large companies like BioNTech and Pfizer, for example, across borders, between large companies and large companies like Merck and Johnson & Johnson, and between companies in India, like the Serum Institute in India and AstraZeneca. There were hundreds of these collaboration agreements. None of them would have been possible without a multilateral, predictable intellectual property system. Who would have trusted that they can give their crown jewels to another large competitor in record time, without the need to spend years negotiating specific agreements? Who would have trusted to do that across borders and across industries without a robust intellectual property system? So I'll come back to Paul Revere. The concerns that I have are basically, in the end, because there are obviously interests, specific interests, economic and political interests that are at the heart of the push for weakening American IP, as I've mentioned. But for legislators and administrators in the United States who have America's best interests at heart, they need to understand the value of IP. And once they understand the value of IP and that we cannot do what we have done without it, they will understand that they cannot listen to those interests that are pushing for the weakening of this important American asset. So let me just finish with Longfellow's last few lines that effectively talk about the hopefulness of the American Revolution and American democracy. Through all of our history to the last, in the hour of darkness and peril and need, the people will waken and listen to hear the hurrying hoofbeats of that steed and the midnight message of Paul Revere. I think if our elected officials listen and understand, they will do what's right for the American economy, which begins, in this instance, with American IP. Thanks all, and I think we have a few minutes for some questions.
Just for one question, I think, if anyone has. I'm sure you do. Peter?
Should American banks, law firms, accounting firms raise money for Chinese companies that claim to have a mountain of patents but only have 219 that are material? And that's their language to shareholders. When this company has been put on the DOD's 1268 list, which means the commercial company helps the PLA, Chinese military. Why should American companies raise money from American retirees to help a Chinese patent fraud?
Well, you don't want, in my view, you don't want to encourage or do anything to support patent fraud. But in the end, so we have to watch to make sure that we don't let into our country for national defense purposes and otherwise foreign interests that are detrimental to the United States. Other than that, in the commercial space, though, I think it's important to treat all patents from all inventors from all countries with equal dignity, and that is what the TRIPS agreement requires, for good reason. And of course, again, I emphasize you have to watch for national security interests, and I think the United States does do that. We have various programs to do that. But if it's just pure commercial, you have to let, in my view, the market system work.
Okay.
One more, Bruce. Back there.
Yeah, you mentioned that, well, you stated that legislators and administrators, and I would add also executives, should understand the importance of IP. What do you think the main reason they don't?
Look, it's a great question. Okay, so first of all, it's just pure education. It's a complicated subject. These people, the folks in this room, we go to a lot of these events and we talk about it day and night. So we get it. But for most people, legislators, administrators, it's just one of many, many issues, and it's a complicated issue. The second thing is, to some extent, IP rules and the impact of IP is counterintuitive. It's much easier to say, well, just remove this roadblock, remove the patent or the copyright, let people have access to it. Let people have access to this fantastic, innovative, life-saving drug, for example. Let's just go, okay? And that's an easier, for the uneducated, initial reaction. You have to understand more to come around to understand the long-term value of IP and that it happens without it. Third, and really important, there is huge money, huge and humongous lobbying efforts, both in Congress and in the administration, for a long time by vested interests to weaken intellectual property rights. And again, for some of the reasons that I've mentioned, including, reducing the price of this important American asset, makes it less expensive. And that has, those interests benefit from that. And people are people. Legislators are people too. And when they're getting bombarded with huge lobbying efforts from one side and much less from the other side, when I was at the patent office, my son says, Dad, with all these people just saying the other side, taking the other side of IP, don't you think you might be wrong? Which I said, no, I don't think so. I think I'm right, but there's more of them than me. So, all right, guys, thank you very much. Have a great day.